Welcome everybody, and thank you for joining us today for this webinar. My name is Karen Sushik. I am a Practice Development Advisor at CYCJ and co-chair of the Multi-Agency Children's Rights at Court group. My apologies that my colleague Debbie Nolan, who also chaired the group, is not with us today. So the group was established to explore how children's rights can be more fully realised for children appearing in criminal courts as accused. To support practitioners and agencies to understand their roles and responsibilities to support and uphold the rights of children appearing at court, we are very excited after months, I think even a year or so, of work to finally be launching the Multi-Agency Guidance Toolkit to support the fulfilment of these roles. The guidance is available as of today on the Youth Justice Improvement Board website, and the link to the full guidance and the summary document has been shared in an email, and I believe will also be shared in the chat function. This is particularly timely as the provisions of the Children Care and Justice Scotland Act in respect of children at court and also police custody go live today. Before we start, just to advise you, this webinar will be recorded and shared on the CYCJ website. So if there are any bits missed, you will be able to go back and listen again. Cameras and mics will be switched off for all attendees, and only the speakers and organisers of the event will have their cameras on. You will, however, be able to use the chat function for questions. As stated already, this will be recorded to share. However, we must request that attendees do not use any other recording devices, either video or audio, including those that are AI assisted. For those of you who may not be familiar with CYCJ, our vision is to work towards ensuring that Scotland's approach to children and young people is rights respecting, contributing to safer communities and better outcomes for our children, young people and families. We are involved in a number of different areas of work, including practice and policy development, supporting participation, which is ensuring the voices of children and young people are at the centre of our work, and research. All this underpinned by knowledge exchange. We have an e-bulletin, which we will link to at the end of the presentation. But if anyone would like to hear any more about our work, please do get in touch. So this webinar to launch the guidance on upholding children's rights at court is happening now due to the commencement today of Section 16 of the Care and Justice Act, which increases safeguards for children subject to criminal court proceedings. Excuse me. This legislation aside, we will also cover other reasons why we felt this guidance was necessary. We will then introduce the guidance and explain a bit about the development process before moving on to cover a few of the stages to the court process in more detail and hopefully highlight how the guidance can be practically applied at each stage. Next, we will cover the working group's hopes for how this guidance may be used and shared to promote the rights of children in court. We will then hear from colleagues from Aberdeen City, Fife and North Lanarkshire, who will share examples of existing good practice and their experiences of reviewing and piloting this guidance. Lastly, we will have a Q&A. We will try and cover all questions today, but if we can't, we will come back to you with answers when we've got them. So we will begin by looking at why we felt this toolkit was needed, looking at what we know from the experiences of children and those supporting them of court, then by looking at the rights and legislative basis for this guidance. The court system is complex and outcomes can be scary. Practitioners know court is traumatic for children and young people. Those of us who have supported children in court will no doubt have seen children anxious, threatening to leave at any opportunity if they haven't been too afraid to even attend in the first place. As this familiar quote from the Promise states, Scotland must consider how to ensure that children have the totality of their cases dealt with in an environment that upholds their rights, allows them to effectively participate in proceedings. Being in court can be confusing and processes complex. Workers and agencies can be unsure of the court processes and existing opportunities that they offer children, and also the communication channels to promote these. Often, promotion of children's rights is on a case-by-case basis, dependent on individual knowledge and experiences on local relationships or processes, rather than cohesive, consistent national standards and easy access to information to promote children's rights. We know from previous research that practitioners can't always advise a child in advance of court where they will go and how proceedings will run, with it not usual for workers or family members to be able to directly support a child during proceedings, as is typical in other child-centred administrative and legal processes. We know practitioners want to improve court experiences for children, but are often unsure what can be done or requested and how changes can be achieved in practice. There may, of course, be options locally to assist children's rights, but often these haven't been previously considered or are only agreed on a case-by-case basis, with a lack of clarity on role and responsibilities common, and often a stumbling block we encountered when trying to clarify points for the guidance. We also heard about limitations to adaptations, for example, due to the nature of the court estate, with it perhaps unusual for separate entrances or alternate rooms or buildings to be made available, even if they exist. Similarly, regarding decisions on potential modifications on how court is conducted, which are made by the judge or sheriff, we found limited awareness on how to inform these decisions we all have a responsibility to think about from a children's rights perspective. We also know that these conclusions are not new to practitioners working with children in conflict with the law who already strive to promote children's rights in court. As we will hear later, we know of great local processes and practice promoting children's rights, demonstrating that aspects of this new guidance is already possible within existing legislation. However, there is a lot of inconsistency and variation, as well as a lack of clarity on what can be advocated for and offered to promote children's rights. Nothing to date we have seen covers practical guidance on how to use policy, good practice learning and legislation to promote children's rights throughout their journey through the Scottish court system. Children's experiences of the traditional court setting are well documented, and they largely indicate that their rights are not respected in this environment, as the quotes seen here illustrate. Children and young people helped review the Glasgow Youth Court, which was established in 2021 to better respond to the needs of children and young people. Many expressed feeling worried or nervous, not knowing what to expect in court, with some worried that not knowing what to do would make them look bad in front of the sheriff. Top right quote here states, "I can say things and it can come across as cheeky, so the sheriff may take it the wrong way. These people have a lot of power." Anecdotal views through CYCJ's regular participation work tells us that children often feel prejudged by professionals for behaviours, and that the unpredictability of things like transport arrangements to and from court can be anxiety-provoking with a lack of information common, and that also being held in cells along with adults is a scary and disturbing experience. These additional stresses can compound existing anxieties, as one youth court attendee stated. "I didn't know how many people were going to be in the room or anything, so I didn't have a clue what was going to happen." Experiences like this can have an impact on how a person presents in court. Children interviewed as part of the Bairnshouse Draft Standards consultation in 2022 also highlighted the importance of information in helping them prepare for court. One participant suggested, "Make sure there's an awareness of what court might look like. You could meet or even just get a photo of the people involved. You could have some child-friendly diagrams explaining court and the jury. You could have a virtual tour of the actual courtroom so you know what it all looks like." The Youth Court Review also noted a lack of privacy in court was felt by social workers to cause children and young people anxiety, and this was also commented on by children and young people. One quote was, I would just rather if it was just like us in the courtroom and not random people watching." Some young people noted that being in the dock was scary and hard to hear, preferring the youth court option of sitting at the table with their defence agent, social worker and the procurator fiscal. Most also preferring the smaller courtroom. Social workers found the table set up easier for explaining to the young person what was happening. This was important given that the complex and confusing language used in court was also a common theme. One quote was that sometimes some of the words they have to use because of the courtroom demeanour, it makes it quite hard to follow. This evidence highlights the difference that preparation and explanations, language, supports, layout and positioning can make to participation. The research also highlighted not all children and young people felt the same. Some didn't mind the dock or the larger courtroom. Some felt they understood most of what was going on. This shows the importance of listening to what we know about children's collective views, which have informed this guidance, and their views as distinct individuals with different needs and preferences, but the same right to the totality of their rights being upheld in court. We will now look at how these rights can be upheld in practice. Before we look at ways to enhance communication with children and young people in court, we will look at the rights base for these requirements. With the UNCRC now in Scottish statute and the participation and welfare of children to be considered in criminal court proceedings under Section 16 of the Children, Care and Justice Act, it is important that these and wider UNCRC articles are considered and respected in all justice and administrative processes. We will now look at some of the key articles for consideration. Article 3. This provides that the child's best interests are a consideration in every decision affecting them. This involves an individualised response to each child, which in turn involves having key information about the child and, crucially, their views. Article 5. This highlights the needs and right for children to have parental guidance to help them understand and make decisions on account of their evolving capacities. This can be provided by a supportive adult other than a parent and reflects the fact that children are not fully autonomous and require guidance to make informed decisions and to support them to manage situations emotionally. This includes within court processes. Article 12, which is commonly referred to as a child's right to participation, requires that the child's views are not only heard but also considered in any decision made that will affect them. This is supported by General Comment 12, which refers to both decisions impacting individual children, for example, their personal account of events or a specific communication need, and also those impacting children collectively. For example, what we know about how children understand the language that's used in legal processes. General Comment 12 also highlights a decision cannot be said to have been made in the child's best interests if their views were not considered. Article 13 highlights children may need and prefer to receive and impart information in certain ways to allow them to understand and process it, in order for them to form and express their views, and that this is their right. Article 40 provides protections for children who have been accused or recognised as having broken the law. It gives them the right to have the matter determined without delay and by a competent, independent and impartial authority or judicial body, and that this must be in a fair hearing according to law, in the presence of legal or other appropriate assistance, and, unless it's considered not to be in their best interests, taking into account his or her age of the situation, his or her legal parents or guardians. The assistance that a child requires will differ depending on their needs and preferences, though it should always involve a trusted adult such as a parent or carer and a legal representative in court, as well as access to advocacy or a particular specialist such as a speech and language therapist as determined by the child's needs. General Comment 24 on children's rights in the justice system provides a further interpretations of Article 40. So under UNCRC, the non-devolved aspects of the UNCRC, known as the UNCRC requirements, are legally enforceable. The UNCRC, particularly Article 40, has many implications for the rights of children in court. This new guidance on supporting the rights of children in the court system covers the child and human rights principles which guide how this process should be for children and what all those working with children in court can do to uphold these rights. We'll focus now on ensuring children's effective participation. Participation, as well as being a standalone article of the UNCRC, is also one of its underpinning core concepts and one of its 4 guiding principles, on account of it being fundamental to allowing all other rights to be accessed. The UN Committee on the Rights of the Child, the UNCRC's monitoring body, publishes general comments which provide additional guidance and support for state parties in taking forward the principles and provisions of the UNCRC. These also provide further clarity on individual articles and their content as in scope for assisting interpretation considerations of these UNCR requirements under Section 4 of the UNCRC Incorporation Scotland Act 2024. As referenced on the previous slide, General Comment 12 on the right of the child to be heard expands on the principle of participation, commenting on its importance in the judicial processes. As the quote here says, this right has to be fully observed during all stages of the judicial process. General Comment 24 on children's rights in the justice system highlights children have the right to be heard directly and not only through a representative, and also at all stages of the process, starting from their first contact. As with the promise, the UN Committee on the Rights of the Child has repeatedly stated that children should not be tried as adults in adult court, and this was most recently stated in its 2023 concluding observations to the UK. Looking also at the UK ratified European Convention on Human Rights, Article 6 states, the court must respect and uphold the right of the accused, including child accused, to a fair trial. This requires that all parties, including the prosecutor, court staff and presiding sheriff, ensure that the proceedings are fair and fully understood by the child. The 1999 ruling of T&V versus the UK states, it is essential that a child charged with an offence is dealt with in a manner which takes full account of his age, level of maturity and intellectual and emotional capacities, and that steps are taken to promote his ability to understand and participate in the proceedings. To address concerns about judicial courts, the Scottish Government promotes the development of specialist youth courts for children and young people, with the Youth Court Blueprint published in 2023 outlining 10 principles to be considered when developing and running a youth court. These include the need for children to be prepared for and supported through court processes, with courts and all those working in the court with children adapting the layout, communication styles and language to adhere to trauma-informed principles and the developmental needs of the child. Steps should be taken to accommodate speech, language and communication, cognitive, processing, social and sensory needs, and to promote the child's participation. The duty for the courts to consider children's participation has now also been written into Scottish legislation under Section 16 of the Care and Justice Act. Section 16 amends Section 50 of the Criminal Procedure Scotland Act 1995. It states that, in complying with subsection 6, which is the court's requirement to have regard to the welfare of the child accused and to take steps to remove them from undesirable surroundings, that the court must now in particular consider what steps might be taken to facilitate the participation of the child in the proceedings while safeguarding the child's welfare and where reasonably practical take those steps. Each child's needs and views will vary, requiring an individualised and tailored rights-based approach for every child at every court appearance. It is recognised that despite aspirations, there may be limitations to what individual practitioners or agencies can achieve, for example, owing to the physical infrastructure of the court estate and limitations to local service provision, or to what extent they can influence the decision of others, with the final decision as to how individual court cases are managed resting with the independent judiciary. Good communication is integral to participation, which means we need an understanding of what communication and speech, language and communication needs are in order to promote good communication generally, but also within specific settings where the interplay of rights, legislative and particular situational demands must be considered. We'll now look at the other legal requirements underpinning this guidance. The 1995 Criminal Procedure Scotland Act has contained legal requirements for children at court for over 30 years. These requirements have been extended by the Care and Justice Act. Section 16, as we've seen, which relates to steps to safeguard the welfare and safety of children in criminal proceedings, goes live today. Also, as of today, certain provisions now apply to all under 18s. For all under 18s, the court must now consider the welfare of the child, take steps to remove the child from undesirable surroundings, and consider steps, as we've discussed, on what might promote children's participation while safeguarding the child's welfare. Protection for children in summary and solemn cases have also been strengthened. Summary protection shall apply now to all under 18s, covering that the court is to sit in a different building or room from that which it usually sits, or on different days from those on which other courts in the building are engaged in criminal proceedings. Closed court is now required with no person present at any sitting for the purposes of such proceedings except members and officers of the court, parties to the case before the court, their solicitors and counsel, and witnesses and other persons directly concerned in the case, representatives of the media, who will obviously adhere to reporting restrictions regarding children, and other such persons as the court may specifically authorise to be there. Although not specifically stated in legislation, this can and should include the social worker and supporter for the child. For solemn cases and cases where a child is co-accused with an adult, there may be different premises, and time, and the court may be closed. Where there is an adult co-accused, the court must also have regard to the rights of the co-accused to effectively participate. Although the legislation is worded in a way that says these considerations may be done, the first UNCRC challenge following the passing and commencement of the UNCRC Incorporation Act related to summary proceedings involving two child accused. In the opinion, it was then concluded that for particular cases involving children, that forthcoming trials ought to take place in compliance with Section 142 of the 1995 Act. So that means that they must call at least in a different room from that in which the sheriff usually sits, or on days when criminal proceedings are not taking place. The proceedings should be behind closed doors, but allowing the press or other specially authorised persons to be present. It is in the 1995 Act, and both the court and parties should ensure that the section is complied with. Some other parts of the 1995 Act will not yet be extended until the raise in the age of referral to the Children's Reporter is commenced, which is anticipated in early 2027. Examples are the legal requirement that any child being conveyed to or from any criminal court or waiting before such an appearance or after in court shall be presented from associating with an adult charged with an offence, unless they are a relative or co-accused. Also, the requirement for a parent to attend court with the child and the local authority requirement to share information with the court on when the child will be appearing is not yet commenced. However, we should still be considering and seeking to uphold these rights of children under the UNCRC and best practice, and particularly given that we know within the next year this will be a legal requirement for children. The toolkit outlines these legislative requirements, but also youth justice standards and policy, with court support for children having been a core domain of the whole systems approach since its introduction in 2011. We're now going to look at the process of developing the toolkit. So the document is published by the Youth Justice Improvement Board, known as YJIB, which was set up under a previous youth justice strategy to forward its objectives, and it continues to do so under the current youth justice strategy, Scotland's Vision and Priorities, seen on the screen. The Children's Rights in Court group was a group which is, a subgroup of the Children's Rights Implementation Group who report to YJIB. And alongside government officials, this group has representation from the Scottish Courts and Tribunal Service, the Crown Office and Procurator Fiscal Service, Social Work Scotland, legal professionals, health specialists, the Universities of Edinburgh and Stirling, and the Children and Young People Centre for Justice. The group has been meeting since 2024, and the two key actions identified were: one, local analysis of the options available in different courts in Scotland for child accused, and this was conducted by Scottish Courts and Tribunal Services and also by local authorities who were directed to do so through their membership of the National Youth Justice Advisory Board. The other key objective was the development of a guidance toolkit and establishing what is required alongside the publication of the document to make these rights a reality in practice. The group also established a forum for practice issues to be raised and developed an information sheet on the social work role in upholding children's rights when deprivation of liberty is being considered, and that link was sent out in the email earlier today. The group recognised the work that has gone into the development of youth courts, however, also that the pace of youth court development has been slow and that most children who have their cases dealt with at court remain in the traditional adult system. They require specific treatment and considerations to ensure their rights are fully respected during this process, which this guidance aims to support. So how was the toolkit developed? It was very much a multi-agency effort, which identified different steps of a child's journey through court and what would facilitate a rights-respecting approach at each step. It highlights associated rights implications in legislation and outlines roles and responsibilities of agencies at each step. Looking at reviewing and refining the guidance, there was draft guidance reviewed by the group and then by 4 local authorities, 1 speech and language therapist, other agencies, and also, importantly, the Lord President's private office and the Sheriff Principal, Clan Child Law, and the Children and Young People's Commissioner Scotland. We had hoped and aimed for conducting a multi-agency pilot, but largely due to time constraints, this proved challenging. However, feedback was sought for consideration from the above-mentioned agencies and recommendations considered, including those around duplication of information and around suggestions merging stages together. The document was lengthy, however, there were limits as to how much shorter this document could be, with the reviewers also highlighting that the thoroughness was beneficial, particularly the rights and legal information for each stage, which was important as it can be quoted when advocating for children. So to some extent, we know the length is lengthy, but also there's reasons for that, and those were appreciated. So to ease the navigation of the document, each of the purple headings for each of the 8 stages can be expanded or retracted, depending on which one you want to look at, by clicking on the triangle on the left-hand margin. This would avoid having to read the whole thing if you're looking at a particular stage. And we've also developed a summary document, which we're going to look at in a minute. Okay, so introducing the guidance, it's predominantly for children under 18, and there's obviously certain legal protections that apply to them, but it can equally, in essence, apply a lot of it to young people and those functioning at a younger developmental stage. It balances the growing level of personal autonomy of older children with the need to provide protection and support to avoid disadvantage and discrimination and to promote consistent approaches. The legal requirements are clear, but they can be challenging to achieve in practice, and the toolkit includes suggestions and further areas for local and national attention. The toolkit breaks the roles and responsibilities of key agencies down at each stage, but an overall summary for each agency is included on the slide. So for police, a key role for them is informing partners that a child is attending court. They will conduct some sort of assessment of need and risk while the child's in police custody to inform how court is conducted, and transport to court is also a potential role for them in terms of arranging that. For social work, a key role for them is identification and assessment of information relating to the child throughout the process, and making sure they involve the child, family and other agencies in this, as well as providing support before, during and after court. It was very much recognised that who is responsible for providing such support will vary by area and circumstances. So in terms of what social work team has responsibility for supporting a child. But the key is that whoever that is locally, the process is clear and it's understood by those working in that area. For the Crown Office and Procurator Fiscal Service, they are responsible for making a decision regarding prosecution, but will also identify that a child is appearing and share information regarding any bail opposition. And where information is identified, they will also highlight it in relation to how a child's needs are to be met within court. Lawyers are key throughout the journey of the child through the court system, and they're a key conduit to court to sharing information, but also to make cases for and request any modifications to how the court is run. And it's bearing in mind that they often have no or limited knowledge of the child, so their ability to do this will depend on agencies like social work sharing information, any information they have, and keeping a kind of close relationship with the solicitor through the court process. The Scottish Courts and Tribunal Service, they've got a key role also in communicating information within the court and with the court, and providing facilities for the hearing when these have been agreed. So things like waiting areas for children and any agreed adaptations they might have to put in place. The judiciary decides on how the court will run and makes any decisions on the modification requests. For health colleagues, all children should be known to some health professional, and they could be a really key source of potential information, particularly around the child's communication needs and preferences and other issues. And where more specialist or detailed assessment is required, local considerations will inform how such services are accessed and how health professionals' knowledge, expertise and skills can support the development of inclusive court processes and environments, and also contribute to trauma-informed approaches. This may include access to speech and language therapy, psychiatry, occupational therapy, paediatricians and psychology. Education services can hold key information to support the assessment of the child's needs in court, and also about any support or modifications they may require to participate. We've developed a process pro forma to aid education in their responding to requests by the local authority to provide information for a child appearing at court. And this was done in partnership with Education Scotland, and we've also shared the link for that resource in the earlier email. Transport providers, whoever is responsible for a child's transport to court will vary depending on a child's situation, so the legal basis for their attending, where they're coming from, and they can have an important role in supporting the child on this journey, and also possibly at court, because they're often the people that are waiting with the child while they're waiting to be called. So within that interaction, they may observe and assess kind of key bits of information that might help with risk assessment and also how a child's court case is conducted. Okay, so just quickly moving on to the stages of the toolkit, we've just chosen two to quickly look at. So stage 2, it looks at pre-court assessment and information sharing. And this will obviously be very much impacted by whether the child is known or not to services already, how much information is available, and obviously also depending on how quickly we know the child's appearing, depending on if they're coming from custody, for example, or from an earlier undertaking. But what we do know is any information held can really help aid a needs-led approach to the child and promotion of their rights in court. And that could be information on their past and current circumstances, their key relationships, their legal status, whether their care experience, for example, education and health information as discussed. And there's also sort of court-specific information relating to the child appearance. So any anxieties or worries the child has about court, any previous experiences, and steps that might help the child participate should also be explored. Any modifications or adjustments that may be required should also be shared before the court appearance. And social work, the child's defence agent, police and the procurator fiscal can all share this information with the Scottish Court and Tribunal Service via designated email addresses. Requests for adaptations would usually come from the child's lawyer or from the Crown Office and Procurator Fiscal Service staff if they know about the information. And this should be ahead of the child's first appearance. Depending on where they're coming from, this might vary in terms of the time, but it should still be done in advance. Information where possible will be provided with any bail assessments requested, and the information shared directly with the court via designated email addresses. Where a bail assessment is not required, the above information should still be shared, and this likely will involve using the same process and designated email address, but you should check out how this is operating locally. Court staff will share this information with the judiciary, who will make the final decision. The child should be aware of what information is being shared and with whom. Stage 6, this covers the introduction to the courtroom, where it will always be helpful for the child to know who everyone is and what their role is, and also requires any information or request from any party on how the court is run to be made, and perhaps considered by the sheriff if the hearing has been arranged in haste or new information has just been made available. The management of the courtroom and proceedings, including closed courts, layout, adjustments, etc., is a matter for the court to decide. Scottish Court and Tribunal Service will make any necessary arrangements within the courtroom as directed by the judiciary. And the next slide looks at what this might involve. So this is just some of the options on the slide here that you could ask for the court to consider. So thinking about where the child sits, how the acoustics are affected, how the court day runs, if it starts later, finishes earlier, depending on if it's a full day the child's to be there, what process is in place, for example, if a child does need something or they don't understand something, is there an agreement as to how they will notify the court as to what they need, and also around any communication needs, etc., within the court process. This is an excerpt from the summary document. The summary document basically contains a sort of quick check guide for each of the 8 stages, and it's done in an editable Word document, which you can use online or you can download and fill in pen. So basically it's got down the side, it's got all the steps that you need to consider and who's responsible for those, and there's space to make notes regarding how that stage has been considered for the child. So just a few examples here about like who is best to support this particular child in court, that he might need breaks every 10 minutes and why that is. So example here being, although it's not a diagnosis, he's got suspected ADHD and he tends to move a lot, and having to sit for a lengthy period, focusing on that might detract his attention, so it explains why that would be 10 minutes. And this is a request, it might not be practical, but it's information on the request. And also a bit there about his anxieties attending court, and not to assume just because he's been before that he'll remember who everybody is and what happened. So it's always good to repeat that information. So that obviously is something you can work on yourself, and you can keep it for each individual child as you might add to it as they go through the process. You might not have a lot of information at their first hearing, but if there's a few, by the time it gets to a further one, you might have a bit more on there. And that's a document that can also be shared. Okay, so looking at the next steps, key for us at the moment is promoting this guidance far and wide, so feel free to help us with that. We also have inputs planned for the judiciary, for solicitors and education staff, and are welcome to any sort of other requests. We do encourage local sharing, as those that reviewed the guidance for us highlighted that feedback is often needed quite quickly in terms of what to do, so as much as this is available, the better. Key agency considerations and communications will be disseminated within those agencies as per usual information sharing, but obviously the wider document can be shared with everybody. We're also looking at adapting our resources for children. We've got a journey through justice on the Just the Right Space website, which is designed for children, and we're currently updating that, and we'll reflect any changes within that, and we'll communicate when that's live. And we also, as we'll see in a minute, encourage the development of local processes. The guidance can allow practitioners to consider what to put in place, but local considerations will inform how that looks. And we know that there's been suggestions by practitioners that forums such as court user groups or child protection committees and service planning partnerships might have a role in developing those, and also that there might be scope for including sort of justice colleagues within those groups as well, in order to make sure that it's multi-agency informed. We also need to look at local multi-agency considerations. So some of the considerations as to where a child might wait, etc., might not be able to be made by one agency. So there will need to be a degree of communication within agencies and thinking what's available locally in terms of perhaps other buildings that are available, and what happens kind of, for example, out of hours if a child's behind after the court day ends waiting on transport. So yeah, we're aware that some areas are already doing that, and we're happy to be a forum to share that information. We're going to continue with our Care and Justice Forum, which Debbie runs, so we can hopefully review any practice issues that arise within that forum, and also share good practice if anyone has anything that's working particularly well. And we will also continue to look at data and monitoring considerations as part of the Act reporting mechanisms, but this also links to requirements under UNCRC monitoring. And that is me done. I am now going to move on to speak to some of our colleagues who have happily and kindly helped us in reviewing the toolkit. some quotes there on the screen. I don't know if it's best if I stop sharing my screen now and come to those that have agreed to support us with this bit. Yeah, okay, I'm going to stop sharing. Or try to stop sharing. There we go. Okay, so in no particular order, I'm going to come, I believe we've got Stephen Grieve here from Aberdeen City. Stephen, you have kindly agreed to share with us some existing practice in Aberdeen that adheres to the principles of the guidance already. So feel free just to jump in, your mic should be enabled.
Yeah, I think Julia is here as well today.
Oh, is she? Sorry, Julia.
I'm here,
Thank
so
you.
I had a slight clash, but I'll maybe start just kind of talk a little bit about the bit that we do before court, and then Stephen can jump in and talk about the clean courts, if that's all right. So yeah, thank you everyone, and apologies if you've already heard me say all of this. I think in Aberdeen we've got long-standing guidance about what the expectations are around support for children who are appearing in court, and processes in place that guidance is sent to any worker, where it's an allocated worker, or to the appropriate team where there is a child listed to appear, so that they know exactly what to expect. So really, really clear on that roles and responsibilities. I've got a process in place for sharing information with the court. So a letter is shared with the court that is also shared with the child and young person, and clear expectations about contact with Stephen's team about where the child can wait. So maybe more so for undertakings for that, but rather than the child having to wait in the main court building, the child will wait in the social work offices, which we're lucky are attached to the court building. We've got good links with Police Scotland and long-standing. We get notification in advance of any undertakings that are listed to appear. And we get notification on the day that there's a child in police custody for appearance that day. So again, the processes are really embedded as to how we support that child, and seek the information to share with the court that's needed, to make sure they're best supported. I'll hand over to Stephen. He'll talk about the process for clean courts that are working well in Aberdeen. Stephen.
Yep. So yeah, we've got what we call as the clean courts in Aberdeen. These are courts, as it said, with the guidance there, that there are no previous offenders appearing in these courts. There is one attached to our court one, which is basically a big room, so that the under 18 can actually sit at the table. The sheriff sits at the table as well. It's a bit more informal than it is in the courts. They don't necessarily wear their wigs or their gowns, and they're actually spoken to directly across the table. And that, again, it's the same idea. It's a closed court, so there's only limited folk that are in there. Social work gets in to help them and support the actual child, but they can also bring in family members as well if that's what they wish for support in that as well. They're normally held. There is certain issues with this, because we were worried when it first started that because it's a clean court, they've got to move the courts from normal courts that they would be held either last thing or first thing in the morning. However, it depends on the marking of the papers. But generally it's quite good, whereas they'll be seen, usually it's a sort of communication between social work, justice, social work, the PF and the court to just justify when this child will be called, and we try and get them to call as a priority depending on when their papers are marked. They are taken in, like Julia said, they can stay in here if they so wish. We normally encourage children and families, if they want to come and support their client, they can come in here and work from here as well, so that they're here to support their client as well, if that's what the client wants. We would also allow solicitors and that to come in here to speak to the client away from the normal mainstream of the over 18s and that appearing in court as well. Sometimes they are seen just before lunchtime or they are seen just after lunchtime, due to when the papers are marked. So we make sure that they're comfortable here, and support. So everything's in place. And as Julia says, we've got a robust process now where we can get, if it's an undertaking, we'll get it in a week in advance of any under 18s appearing on undertaking. So we can then look at that and see if they're in relation for them being in a diversion from prosecution to save them actually coming into court. So we'll have a look at that and identify, and then make contact from any allocated workers or the reception team to ask for the letter that Julia spoke to. And then we'll then send that to court through the Bail and Release Act. So either on the day, or if we get in advance, we'll give it to the sheriff to use for the information to make sure that there's less opportunity that secured care would be required in that. And then from there as well, it stipulates about supervised bail or EMO and that as well.
Thanks very much. I mean, that all sounds absolutely fantastic. And you did allude there, Julia, a lot of that is, you know, the fact that the office, the social work office is there, that's fortunate. But a lot of it is established processes, and you're working on relationships, there's great communication, and it's well established. So it just goes to show that that can be achieved.
Absolutely. And the majority of our children, our data shows us quite clearly that if those that are listed to appear undertaken, the majority are diverted from prosecution. So that link in with Stephen's team getting that information, the diversion coordinator is able to have those discussions ahead of time. Sometimes the child doesn't find out till the day, but it's still a good option and good outcome for that child. So yeah, I think these processes are definitely working and understood by everyone.
Yeah, I think it's important as well. I mean, last week it highlighted we were due to have numerous under 18s attending in court, but we were able to speak to children, family social work, justice social work, the PFs and the court to arrange for that not to happen, because there was many concerns in relation to that. But because of the great communication that all the parties have got, we were able to avoid that.
Yeah, that could have been quite a challenge, that particular one. So yeah, good outcomes.
Excellent inspiration to us all. Thank you so much. I'll ask you, we hopefully have time for a few questions at the end, so I'll keep you on hand for that, but I'll just move, thank you. I'll move on. I think we've got Nicole Savage and Stephen Clemenson from North Lanarkshire Council. And North Lanarkshire reviewed the guidance toolkit at an earlier stage for us, and I think hopefully we've got them here today to give us a wee bit of insight into how they found that.
Thanks, Karen. Can you hear me okay?
We can do, Nicole, thank you.
So the feedback I just want to kind of give today was really more about the process of evaluating the toolkit pre-launch. So myself and Stephen were part of a network bringing together practitioners who we'd sent the document out to previously, and then we got them together and created a focus group. And from that, we really found that there was it didn't surprise us, but it was interesting to note the strength of feeling from workers about how necessary the toolkit is, and also how the toolkit can be used as a multi-agency discussion forum. I think from a trauma-informed perspective, what practitioners were really saying was that they find the court process overwhelming, and that translates directly into how families are feeling and children are feeling. And the way that the toolkit is kind of laid out with, it's very, very obvious the needs and the links to the UNCRC, and workers can make those direct links and work alongside the solicitors to really put upholding rights into practice. So I think that's the only really thing I wanted to say today, is that the toolkit in itself can be used as a multi-agency discussion tool. And I think it's really worthwhile, because what we did was we heard the voices of practitioners, and we were also able to pull out thematic issues about specific courts or things that were coming up, and then actually build bridges between that, and that's necessary. One of the kind of frustrations, I suppose, that can be highlighted was that practitioners were aware that if they have good links with their local courts, then it serves such a good purpose for supporting young people. But where that kind of falls down is that young people are quite transient, and so they go all over the place. And so we had practitioners that were having to go to different courts across Scotland, and how that can be a bit of a challenge as well, because courts operate so differently. So the expectations on that we need to be doing certain things to ensure that things are more consistent, and that we've got young people that can have their expectations, that we can explain the processes to them, and we can have a really confident workforce, is going to be really good, and that we're going to continue to use the document as a learning tool and a development tool in North Lanarkshire. Stephen's on as well, and he might have another couple of things to say, but I think what was important for us is that you guys listened as well and offered a summary document, because practitioners were feeling it was lengthy. We understand why it needs to be lengthy, but I think it was more symptomatic of actually saying that out loud to practitioners, and how many different pieces of the puzzle there are when you're thinking about court, and having a bit of a kind of toolkit or guidance around that to support practitioners and how they feel they can use that and pull that out. We've already had some people kind of feeding back that they've been using it, and so we're going to try and collate some of those and feedback to you on a continual basis. That's all right.
Amazing. Thank you so much. I'll just quickly ask Stephen if he wants to add anything before I comment on that.
Thank you. I've not really got too much to add. I think Nicole covered it all there, but I think the toolkit will help promote consistency across the different court buildings. We predominantly cover Airdrie and Hamilton, which, if anybody knows those buildings, are two very different court buildings. So even for workers, just those different environments can be quite different and intimidating, and also quite a lot of time spent in Glasgow Sheriff for workers as well. So you can have different experiences in all those buildings. So, the toolkit will really help promote the consistency. And I think a few people have mentioned that the relationships with the solicitors, I think, can be key in helping them work towards a toolkit as well, and really advocate for that with the young people and with the social workers in the court environments.
No, that's really great to hear. Thanks for that. And I think that was our kind of hope, that by having it all in one place, you could jump to the stage that the child was at and check, right, what's underpinning what we need to do here and how do we use it. So it's really great to hear that that's working, and absolutely welcome any ongoing feedback. And I think it's crucial as well, the point there will be differences, but if this helps everybody in every court area, every sheriffdom, every local authority have processes, even if they change between courts in that area due to sort of physical restraints within that court, as long as we know what that is, no matter where a child's going, you should be able to find out how that process should go in that court, even if it is different. At least it's that having that knowledge in advance. So hopefully that's something we can work towards. And lastly, I'm just going to come to Sean. Sean McIntosh is here from Fife. And they also helped review the toolkit for us. Thank you, Sean.
Yeah, just to share some of our experiences with reviewing this. I think a lot of this was kind of covered in Nicole. So one thing we found is it's really helpful in preparing children for what they're likely to experience within court. I think a lot of, obviously, children, this will be their first time going, but also it's helping our staff prepare as well. We, in our model, we have we're not justice workers working with children. We're actually children and families workers who are becoming used to a justice process that's still not very clear. But you're learning as you go a lot of the times, and actually it's helping our staff in terms of their development. But I will say we have had some excellent experiences of sheriffs who understood that the hearings were about the needs of the child, some very, very differently. Just one example to speak to, we had a child appearing virtually for an appearance from Secure. This child had been denied a virtual hearing on multiple occasions previously, and we felt it was in our best interest. The sheriff removed their wig. They made themselves very accessible to the young person. They reduced the length of the hearing. They had a significant amount of the discussions in advance, and they wanted to give the child the opportunity to participate, but in a way that they wouldn't become overwhelmed. It was a really fantastic experience for the young person, and feeling listened to by the sheriff, and feeling that he understood her needs. And just to say, a lot of the times we feel like they don't get that right, but sometimes some sheriffs are really understanding of why things have to change, and we really like being a part of that. I'd say some of the difficulties we're having is around timing and the structuring of young people appearing. we have children appearing in closed courts but remaining within an open court for the entirety of the day before that happens. I think that has to stop. Sometimes they're seen at the end of the day, sometimes in the middle of the day. We're really looking for a bit of consistency. And I think the toolkit, when we've kind of reviewed this and we've reached out to our staff team, and what was really helpful for them is there's a recognition that everybody is responsible for meeting the needs of a child. And I think that really, that's where we're recognising that these are children in need, and it's very similar to kind of GIRFEC. Everybody has to take a role in making sure this works well for them, rather than saying it's social work's responsibility and you're not working together with other people. And I think being able to hold people to account for what they haven't done at this point, and I suppose as then being able to speak to the court to explain why a young person's experiencing what they are, or what we need to be different in the next time, it's really good at helping us, keeping us to account, but also everybody else is involved in the child's journey. So that's us.
Thank you very much, Sean. That's a really excellent example there in terms of those pre-discussions and in terms of how that impacted the day. And I think that's partly why it was so positive that this was written into legislation, because the UNCRC Act had been commenced, but often with rights-based legislation, it's everyone's responsibility. So in practice, it's hard to pinpoint whose it is. So I think hopefully as a tool for multi agency to use, it can be something that can really get everyone thinking about that and thinking, what can I do and what can other people do, and have those discussions.
Can I say as well, I think one of the things that we do well is we become involved with children at a very early point compared to what they would expect from a justice team beforehand. So, for example, if they have been charged, they're on an undertaking, we wouldn't traditionally know. So we'll involve us, or we try and support a young person at an early point. And actually, that really makes a difference, in terms of supporting them through your journey. It's not just the week before in terms of talking through the court. We've done our assessment. We can make a recommendation. We feel like we know the young person and able to, base our views based on what we think's right for them, rather than just on the basis of a before thing. So I think working with them as children in need, rather than young adults who are at risk, is absolutely crucial for getting this rights respecting model right.
Yeah, absolutely agree there. And that's where the difference being, if you're getting that notification earlier, you can start that process and you're hopefully not scrambling around at the last minute, and you can get things in place for the first or earlier appearances, which might not have been possible. That's really, really good to hear. Thank you. I'm just going to, sorry, a couple of minutes left. I'm just going to pop to the chat and see if we have any questions. Feel free to pop something in if you do. Also, feel free not to. But take advantage of those that are here. I do appreciate the link to the toolkit only went live this morning, so I would imagine I would, if anyone's managed to read the whole thing, you hadn't a previous sight of it. So feel free to get in touch following this, because once you've had a chance to read it and look to implement it, if there's any questions, by all means get in touch with us and we can try to answer those. Question there linked to the toolkit. I believe that we did send an email around earlier today with a link to the toolkit and the summary document. And my colleagues, I think, have also popped it in the chat. If not, they will do so now. It's at the top. Yep, we're going to repost it, but it should be at the top of the chat. And if you're looking for it in a hurry, if you just go online and look up YJIB, it's on the resources section of their page. There's just a list of everything they've published, and that includes this guidance and also the police custody guidance for section 15 of the Act, which also goes live today. And there's a webinar on that also on our website. Question there, have education received briefings regarding the information request pro forma? I'm not sure, I can check though. It was done in conjunction with Education Scotland and it was completed a few months ago now, so I would hope so, but I can certainly find that out. And I think I saw, another comment there about the marking of papers and waiting all day for a child to be seen at court, which can be distressing. And this is an issue that we've had commented on, and I suppose the answer to that is there needs to be due process. That's also a child's right. So marking of cases will depend on how long that takes, and that there's not a lot of control we have over that. We know they are prioritised within that process, but it can still be time consuming, and I suppose that's where the process of looking for other alternatives, such as what Julia described there, in terms of more child friendly, less traumatic spaces for a child to wait, and having that arrangement when they can then, you know, be on standby almost. So I appreciate that's not something that everyone can possibly do as of today, but it's just something to start thinking about, making that wait a bit less distressing for them. So that is half one. We're going to wrap up here. So thank you so much to everyone for attending today. Please get in touch if there's any more questions, or you think of anything retrospectively, or have any feedback on the toolkit, because we're keen to, you know, update it and share good practice as best we can. So I will leave you all now, and thank you very much for attending.